and in particular to consider the current legal framework regarding statelessness, both at the international and regional levels. I want to particularly welcome the petitioners who have requested this hearing, and they include the United Nations High Commission on Refugees, the SAHIL, and the Open Society Justice Initiative and Refugees International. Welcome all. I'm joined today in the discussion by my fellow commissioners. I have also the second vice president of the Inter-American Commission, Commissioner Rosa Maria Ortiz, who is also the country rapporteur for Haiti and Dominican Republic. I also have Commissioner Felipe Gonzalez, who is the rapporteur on the rights of migrants and migrant workers and displaced persons, and to welcome also the Executive Secretariat and its specialized specialist in relation to migrant workers as well. I want to give the petitioners about half an hour or so to make your presentation, to allow for discussion between the Commission and yourself about this important issue. Welcome again. And I invite you to introduce yourselves.
Muchas gracias, señora presidenta. Nuestra presentación será dividida en 4 partes. La primera de ellas será en español. Honorables comisionados y comisionadas, en primer lugar queremos expresar nuestro más sincero reconocimiento por la convocatoria de esta audiencia, la cual reitera el compromiso que la Comisión Interamericana tiene con el tema de la apatridia. La delegación de los peticionarios está conformada por Francisco Quintana, quien habla del Centro por la Justicia y el Derecho Internacional CEGIL, acompañado de mi colega Charlie Abbott, por la Oficina del Alto Comisionado de las Naciones Unidas para los Refugiados, Booty Cale, representante regional adjunto para los Estados Unidos y el Caribe, y Katie Tobin, oficial senior de protección. Por Open Society, a mi derecha, nos acompaña Julia Harrington, oficial legal senior, y también están con nosotros Laura Bingham, oficial legal, Liliana Gamboa, coordinadora de proyectos, y Mark Kupaski, oficial de programa. De Refugee International, Sarnata Reynolds, quien además trajo materiales sobre la temática apatridia que demuestran el modelo que se han adoptado otros países para combatirla y prevenir la apatridia, tocando diferentes temas como la discriminación en Myanmar, la privación arbitraria en Sudán, discriminación de género en Kuwait o temas relacionados con refugiados en Bangladesh, que no van a ser discutidos en esta audiencia, pero son modelos a seguir para el tema que vamos a tratar. La apatridia, señores comisionados, es un problema que afecta a más de 12 millones de personas en el mundo. Sin embargo, el número exacto de la población afectada en el continente americano es incierto, lo cual se debe en gran medida a la falta de herramientas necesarias para la identificación de este fenómeno. La apatridia tiene un impacto devastador en la vida de las personas. Una persona apátrida enfrenta dificultades para obtener documentos de identidad, asistir a la escuela, recibir atención médica, postularse para determinados cargos públicos, acceder a un empleo formal y en ciertas ocasiones incluso corre el riesgo de ser sujeta a una detención prolongada. Por lo anterior, podemos afirmar que tener una nacionalidad es un requisito necesario para vivir una vida digna. A las personas apátridas les es negado precisamente este derecho. Las organizaciones aquí presentes queremos compartir algunas observaciones y análisis sobre la condición de apatridia en el continente y formular recomendaciones a esta honorable comisión para que a través de sus diversos mecanismos pueda dar mayor seguimiento a esta situación y así incrementar la promoción y protección de los derechos humanos de las personas apátridas. En este sentido, quisiéramos mencionar algunas de las formas en las que la Comisión Interamericana podría trabajar o impulsar a los diferentes temas que aquí serán tratados. En primer lugar, nosotros consideramos que esta temática debería de ser tratada por parte de la Comisión Interamericana de una manera transversal, es decir, no solamente la Relatoría de Migrantes puede analizar esta situación, sino otras relatorías, como será expuesto más adelante. La Relatoría sobre Discriminación podría hacer estudios también sobre esta materia, la Relatoría de Niñez o de Mujeres. Por esto, la Comisión debe mantener el estudio de esta problemática en su agenda, incluirla en su plan estratégico e incorporarla en sus diversos mecanismos, ya sea a través de una visita in loco, tenerlo presente para analizar la situación e incluirlo en sus diversos informes que a bien tenga emitir. Sin perjuicio de ello, sería importante también que la Comisión incorpore los temas que aquí se van a tratar en un informe especial sobre cómo combatir la apatridia. Sin más, quisiera dejar la palabra a mi compañera Katie Tobin, quien hará una breve introducción del mandato de la Oficina del Alto Comisionado para los Refugiados.
Can you hear me now? Good afternoon. On behalf of the United Nations High Commissioner for Refugees, I wish to thank the Inter-American Commission on Human Rights for granting us this opportunity to engage on this important issue of statelessness in the Americas. UNHCR has a formal mandate to prevent and reduce statelessness and also to protect the rights of stateless persons. We see events like this as an important opportunity to move forward in realizing our mandate. The scope of our work is spelled out in the 1954 Convention relating to the status of stateless persons, as well as the 1961 Convention on the Reduction of Statelessness. In pursuit of our mandate in the Americas, UNHCR is involved in promoting accession to the international instruments on statelessness, as well as promoting nationality laws, and also working to build capacities with both governments and civil society partners that are working to address the issue. While UNHCR is the agency mandated within the UN system to confront statelessness, it is a priority for the United Nations as a whole. In 2011, the United Nations Secretary General described addressing statelessness as a foundational and integral part of UN efforts to strengthen the rule of law. UNHCR deeply values its ongoing relationship with the Commission and the Organization for American States on Statelessness and other matters. UNHCR has signed memorandums of understanding within the last decade with both the OAS and the Commission. Many of our recommendations today are drawn from those MOUs. With no further ado, I will turn it over to Ms. Julia Harrington-Reddy from Open Society Justice Initiative to provide a legal framework on statelessness.
Thank you very much. It's my great honor and pleasure to be here. The Open Society Justice Initiative has for almost a decade now worked on the linked issues of right to nationality and statelessness through a variety of means, including litigation, documentation, and general advocacy. Let me say that my oral presentation cannot possibly be comprehensive because there is a very large number of international treaties and international soft law resolutions, declarations that bear on the right to nationality and statelessness. So I'm going to present only a few highlights, and the Commission will receive a substantial number of annexes that give you further insight into what the legal framework is. I'll start with the Universal Declaration of Human Rights. Article 15 states everyone has the right to a nationality. Today, the Universal Declaration is considered, for the most part, to be customary international law. So everyone's right to a nationality, every human being's right to a nationality is in principle binding. Individual states are responsible for regulating their own nationality laws, resolving who is a national and who is not. Most national-level nationality laws aim to recognize an individual's connection with a country through birth, ancestry, or residence, and then use those links as a basis for granting legal citizenship. All people have such links with at least one country, but the laws of that country may not recognize these links, or individuals may be denied citizenship through arbitrary or discriminatory application of laws. In its advisory opinion, 484 of 1984, the Inter-American Court stated that in the regulation of nationality, that's the advisory opinion on Costa Rica, the Inter-American Court stated it is not only the competence of states, but also the requirements of the integral protection of human rights that intervene. when it comes to deciding matters of nationality. This means that although states have the discretion to fix their nationality laws as they wish, as a core function of their sovereignty, state actions must be consistent with the international legal human rights framework, including norms of due process and non-discrimination. The Inter-American Declaration, Article 19, recognizes the right to nationality. The American Convention on Human Rights, Article 20.1, says every person has the right to a nationality. The American Convention, Article 20.2, elaborates. Every person has the right to the nationality of the state on whose territory he or she was born, if he or she does not have the right to any other nationality. And Article 20.3 of the American Convention says that no one should be arbitrarily deprived of his or her right to nationality. The right to nationality, including the prohibition on discrimination and access to nationality, is contained in many other international instruments, including the United Nations International Covenant on Civil and Political Rights, the United Nations Convention on the Elimination of All Forms of Racial Discrimination, the United Nations Convention on the Rights of the Child, the United Nations Convention on the Elimination of All Forms of Discrimination against Women, the European Convention on Nationality, and the African Charter on the Rights and Welfare of the Child. So you can imagine why I'm not going to quote you the treaty provisions from each of these, because I would exhaust all of us and exhaust our time. But just last year, the United Nations Human Rights Council, in its resolution 10/13, affirmed the right to nationality and called upon states, quote, to refrain from taking discriminatory measures and from enacting or maintaining legislation that would arbitrarily deprive persons of their nationality on grounds of race, color, sex, religion, language, political or other opinion, national or social origin, property, birth, or other status, especially if such measures and legislation render a person stateless. In practice, the most common problems with respect to right to nationality fall into four main categories: non-discrimination, due process, children's right to nationality, and the necessity to avoid creating statelessness. So I'm now going to mention a few of the chief authorities that relate to each of these four problematic areas. Non-discrimination on the base of race and ethnicity is a jus cogens norm of international law. The International Covenant on the Elimination of All Forms of Racial Discrimination specifies that states parties must undertake to prohibit and eliminate racial discrimination in all its forms, and it guarantees the right of everyone, without distinction, to equality before the law in the enjoyment of the right to nationality. The Committee on the Elimination of Racial Discrimination, interpreting the International Covenant on the Elimination of All Forms of Racial Discrimination, recognized that deprivation of citizenship on the basis of race, color, descent, national or ethnic origin is a breach of states' parties' obligations to ensure non-discriminatory enjoyment of the right to nationality. That's in the committee's general recommendation number 30. Deprivation of nationality that is based on racially discriminatory criteria in law or practice is per se arbitrary, even if due process guarantees are in place. Racial discrimination with respect to deprivation of nationality contravenes jus cogens norms, the international prohibition on racial discrimination. So we come to due process. Due process is a particularly vexed issue with regard to citizenship. In practice, in most countries, the issuance of identification documents is an administrative function. So as a practical matter, determinations of citizenship are being made by lower-level administrative officials. Where such officials decline to issue identity documents, individuals are effectively denied the right to citizenship that they have under law. Citizenship determination, and certainly citizenship deprivation, should be done according to processes that offer protections not less than those that pertain to criminal law. So this preamble essentially relates to the qualification arbitrary. In the Universal Declaration, Article 15, it says, no one shall be arbitrarily deprived of his nationality. So any determination or deprivation that doesn't respect due process norms is prohibited by the Universal Declaration Prohibition on Arbitrariness. This commission, the American Commission, on human rights found in the case of Ivcher Bronstein versus Peru that the right to due process, safeguarded by Article 8 of the American Convention, is applicable to all types of judicial or administrative procedures that involve the determination of rights. So that would include, logically, determinations of citizenship. In his 2009 report on arbitrary deprivation of nationality, the United Nations Secretary General emphasized the particular importance of due process guarantees in the context of determinations of the right to nationality. So we move on to children's right to nationality. The principle that states should grant citizenship to children born on their territories who do not acquire any other nationality at birth is emerging as a general principle of international law. As I stated previously, it's contained in Article 20.2 of the Inter-American Convention on Human Rights. I'll quote again, "Every person has the right to nationality of the state on whose territory he or she was born, if he or she does not have the right to any other nationality." This principle is also contained in the United Nations Convention on the Rights of the Child, the African Charter on the Rights and Welfare of the Child, and the European Convention on Nationality. States usually do accept this principle, but they don't apply it in practice. The most common justification for refusing to abide by this principle is that the children concerned would not otherwise be stateless, but do have another nationality. Recent jurisprudence of the African Committee of Experts on the Rights and Welfare of the Child highlighted that where this justification is invoked, it's the obligation of a state to implement the principle proactively in cooperation with other states, particularly where the child may be entitled to the nationality of another state. In principle, this means that states must undertake, quote, meaningful efforts to ensure that children acquire the nationality of another state if these states deny citizenship to children born on their territories on the grounds that they are acquiring another nationality. The International Convention on the Protection of the Rights of All Migrant Workers and Members of Their Families also specifies in Article 29 that the children of migrant workers have a right to nationality. It's particularly important to highlight and reiterate this right because there's a disturbing trend, even in countries that practice jus soli and grant citizenship in principle to individuals born on their territories, to deny citizenship to children whose parents are undocumented. So, with respect to statelessness, where there is racial discrimination in access to citizenship, where due process protections are absent, and where children's right to nationality is not protected, that's where statelessness is likely to occur. The most important principle, single most important principle for reducing statelessness is the one just discussed, that states should grant nationality to children born on their territories who would otherwise be stateless. This is Article 1 of the Convention on the Reduction of Statelessness, the United Nations Convention on the Reduction of Statelessness. The convention further provides that contracting states must grant nationality if a person is born to one of their nationals outside the contracting state who would otherwise be stateless. This overlapping responsibility ensures that anyone born in a contracting state of the UN Convention on the Reduction of Nationality or born outside the contracting state to parents who are citizens would never become stateless. Article 8 of the Convention on the Reduction of Statelessness expands on this principle, stating, "A contracting state shall not deprive a person of its nationality if such deprivation would render the person stateless." And this principle of prohibition of deprivation of citizenship where the person would be left stateless certainly should be recognized as an emerging principle of international law. Let me speak briefly about the jurisprudence on citizenship. Prior to the past decade, citizenship issues have not been much litigated at the international level. That's beginning to change, and the strongest jurisprudence in the world on the right to citizenship is from the Americas. The Inter-American Court, in its landmark decision, John and Bosico versus the Dominican Republic, taken in 2005, affirmed the human right to nationality as the prerequisite to the equal enjoyment of all rights as civic members of a state. The court, in its decision, Jean and Bosico, reiterated the principle that I've just discussed here, that states should grant citizenship to children born on the territory who would otherwise be stateless. But with respect to citizenship generally, the court held, the court considers the failure to recognize juridical personality harms human dignity because it denies absolutely an individual's condition of being a subject of rights and renders him vulnerable to non-observance of his rights by the state and other individuals. I think we couldn't say it more clearly than that. Thank you very much for this opportunity, and we're happy to answer questions.
It's a pleasure and honor for me to be here on behalf of UNHCR, and as stated, my name is Buti Kale. I'm the Deputy Regional Representative for the United Nations High Commissioner for Refugees here in Washington, D.C. Would like to reiterate our gratitude to the Inter-American Commission on Human Rights for this opportunity to join hands with NGO colleagues to discuss this important issue on statelessness and human rights. There are some of the issues that have been highlighted by my colleague, Julia Harrington-Reddy, one of which is non-discrimination, a fundamental principle in this area of statelessness. And I will be coming back to that particular principle as well as I give the Commission an overview of the causes of statelessness. It is of fundamental importance for us to understand the causes if we were to reduce or prevent the phenomenon of statelessness. Now, statelessness stems from issues related to nationality, and a term that we could also interchange with another one, which is citizenship. And there are a number of situations in the Americas where specific individuals and populations are either stateless or at risk of statelessness in the countries where they were born or where they currently reside. I am going to give you a few causes, and as Mrs. Harrington-Reddy explained, we are not in the position to cover all the issues that are of importance on this particular subject matter, but I will try to give an overview of, let's say, the 4 causes of statelessness, starting with the issue of discrimination. And discrimination that is also enshrined in some countries, either in the constitution or in the legal provisions of the countries themselves. If we were to take, for example, the issue of gender discrimination, in some cases, as it is the point in the Bahamas, where, for example, a Bahamian woman who gives birth to a child outside the country is not in the position to confer nationality to that child. And the Bahamian government is in the process of reviewing the constitution by having instituted a commission in order to look at this particular issue. And the other example is that of Barbados. The constitution in that country has been amended in order to repeal this discriminatory provision, but unfortunately the laws of the country have not been put in alignment with this positive constitutional development, which is also a problem. The second cause of statelessness is disputed or undetermined nationality. When one looks at the persons of Haitian descent who are in the Dominican Republic, there is a significant number of these people who have got their nationality either disputed or undetermined. because the government has adopted legislative and administrative measures in order to question, for example, the validity of a number of birth certificates that were issued to persons born in the country, and that engenders a situation of instability, and that could also lead to a situation of statelessness, particularly when there is a conflict of laws of nationality, and especially before the Haitian constitution itself was amended, that is in 2012. Another cause relates to limitations on conferral of nationality for children born abroad. And it has been emphasized by Mrs. Harrington that, for example, the Convention on the Rights of the Child does stipulate that a child has got a right to a nationality, whether the child is born in the country of origin of the parents or abroad, especially in a situation where the child would otherwise be stateless in accordance with Article 1 of the 1961 Convention on the Reduction of Statelessness. And this phenomenon of the loss or the risk of loss of nationality or the non-acquisition of nationality may be identified in a number of countries, unfortunately, in the Americas. And one of them is the Bahamas, where children of the second generation born to parents who were born abroad may not be in the position to automatically acquire Bahamian nationality. They would then have to wait until they attain the age of 18 and then apply. But again, with that kind of registration, there isn't any guarantee that the person would acquire a Bahamian nationality. Canada, again, is one of those countries with the recent enactment of a law on nationality that also is pretty much the same thing, which simply means that a Canadian who was born abroad, who gives birth to a child born abroad as well, may not be in the position to acquire Canadian nationality unless they're looking at three conditions. One, unless that person is otherwise going to be stateless, and which is again in conformity with Article 1 of the 1961 Convention, to which Canada is a party but not party to the 1954 Convention. And in that case, then the person is likely to acquire Canadian nationality. And again, the person has got to be under 23 years of age. And the other thing is that the person would need to have resided in Canada for at least 3 years out of the 4 years preceding the date of application for citizenship. Chile, the same kind of problem. Cuba, unfortunately, same kind of problem. A person finds herself outside Cuba and gives birth to a child, which child may not be able to acquire Cuban nationality, even if Cuba does follow the bloodline principle or the jus sanguinis principle, simply because the person who gave birth to the child has been outside Cuba for quite some time and may not even be able to be readmitted into Cuba. It used to be 11 months and 29 days. It's now 2 years with the recent changes in Cuba. Paraguay, same. USA, it is the same kind of situation with a tinge of discrimination in a sense that you are here looking at a U.S. citizen father giving birth to a child with a non-U.S. citizen mother. And in this case, the U.S. citizen father, in order for him to have the child have his nationality, that is the U.S. nationality, he has got to meet heightened requirements. He has got to show clear and convincing evidence, including, for example, the test that would attest that the person that the U.S. citizen person is the biological father of this person, and this has got to be in a situation where the child was born out of wedlock. Another cause is we're looking at people at risk of statelessness due to gaps in civil registration and documentation systems. And it is important, obviously, having a civil status document does not necessarily mean that a person is a national of the issuing state, but it does assist with the avoidance of statelessness or the risk thereof. So it's of utmost importance that states arrive at this universal registration of births, and that is why the Organization of American States, through its program, has been promoting universal civil registration. And this, in some cases, you have dysfunctional and ineffective civil registration and documentation systems that create a risk of statelessness in various countries in the Americas. And common problems would include strict time limits for birth registration, the high cost of birth registration or issuance of personal documentation, poor infrastructure and transportation, lack of understanding on how to ensure the application of dual nationality regulations, and lack of awareness and education of parents on the need to register their children. The last cause, which may not necessarily be a common phenomenon in the Americas, but we are highlighting that simply because you do have individuals who come from countries that got dissolved at some point and came and settled in the Americas, and in particular in the US and in Canada. And these individuals find themselves in a situation of statelessness simply because they could not fulfill some of the strict administrative requirements of the countries in which they used to live. I will conclude this presentation with a few recommendations for the Commission, and the first one being for the Commission to encourage the states that have not as yet done so to accede to the statelessness conventions, to the 1961 Convention and the 1954 Convention in the Americas. I think there are roughly 16 or so countries that have that are parties to the 1954 Convention, and about 11 of them that are parties to the 1961 Convention. The second one is to mainstream all statelessness issues into all available monitoring mechanisms of the Commission, which could assist not only in awareness raising, but in continuing as well to prompt states into working on the issue of reduction and avoidance of statelessness. And also to draft a specific thematic report on the subject of statelessness in the Americas for information exchange and research on statelessness issues, and to also engage in comparative legal analysis jointly with UNHCR on nationality issues. And some of these things we have already started with the Commission, and as it was mentioned by my colleague Katie Tobin, on the issue of the MOU that exists between the Commission and UNHCR to promote amendments to nationality legislations that could be at loggerheads with national, regional, international human rights principles and norms, and as well as to undertake joint promotional and training activities with UNHCR. And as mentioned, we did do it, and I think that the last one on statelessness dates back to a year ago in February 2012, and we have also touched on statelessness issues late last year as we were working together on the course on international refugee law. And thanking you very much for your attention, and we are ready for your questions.
Thank you very much to all the organizations represented here. And I want to first invite Rapporteur on Migrant Workers and Displaced Persons to offer observations or comments.
Bueno, muchas gracias a los participantes en esta audiencia por sus presentaciones. Creo que han sido muy ilustrativas y permiten tener un panorama de conjunto desde el punto de vista del derecho internacional y de la situación de hecho en los estados de la OEA, lo cual es muy útil para la relatoría y para la comisión como conjunto también. Como ustedes mismos resaltaban, esto se refiere a temas propios de otras relatorías de la comisión, además de la de migrantes, de manera que en ese sentido es importante enfocar esto desde otro punto de vista. La comisionada Robinson, vicepresidenta primera de la comisión, es también la relatora sobre derechos humanos de las mujeres, y la comisionada Ortiz es la relatora sobre niñez. Entonces, también es relevante su participación. Ahora, yo no me voy a referir a ningún estado específico, considerando que es una audiencia general. Aquí se nos han presentado observaciones sobre una serie de estados a título ilustrativo, pero como no es una audiencia de estados, ni están por lo mismo ellos representados, yo no me voy a referir a un estado específico o estados específicos. No obstante, quisiera levantar un par de asuntos para escuchar sus puntos de vista, que tienen que ver con situaciones que se dan en el contexto de algunos estados de la OEA. En primer lugar, la manera en que se ha confrontado en otros sistemas internacionales situaciones en las cuales hay disposiciones de derecho interno, legislación interna, que no se refiere expresamente a un grupo para los efectos de regular la nacionalidad, y en ese sentido no sería discriminatoria de manera explícita, pero que en los hechos produce un impacto desproporcionado en un determinado grupo. O sea, no es como la legislación antigua nazi que podía decir que los judíos expresamente quedan privados de una serie de derechos por el hecho de ser tales, pero que en la práctica tienen un impacto desmesurado. Yo quisiera ver que nos contaran más experiencia al respecto y cómo han trabajado sus organismos, y especialmente ACNUR en este sentido en otros sistemas y en otros países. Y lo segundo es otro tema que también es relevante, me parece. O sea, uno de los temas que se mencionó aquí fue el de privación de la nacionalidad, ¿no es cierto?, del hecho de que se le quite la nacionalidad a una persona que ya la posee. A veces los estados invocan para ello el hecho de que anteriormente a esas personas se les había concedido una nacionalidad por error en el funcionamiento de su propio registro civil o de las otras entidades del Estado encargadas de conceder la nacionalidad a las personas, darles documentos de identidad, otorgarles pasaporte, etcétera. También sería interesante escuchar de ustedes cómo enfocar ese punto, porque claro, hay un tema que puede ser de error, efectivamente, que a veces se entregan identidades, y otras veces esto puede tratarse de una práctica deliberada. ¿Qué elementos, qué criterios tener en consideración para distinguir una y otra situación?
Vice President.
También me sumo a los agradecimientos manifestados por el comisionado González. Es un tema que toca de cerca a la Relatoría de la Niñez y hay mucho interés en trabajar en conjunto con ustedes. Comparto con ustedes todos los señalamientos que han hecho de los distintos tratados que velan por este derecho a la nacionalidad. Y quería hacer mención a que la Convención de Derechos del Niño, en sus artículos 7 y 8, que se refieren a el derecho a la identidad, tiene tres elementos que configuran la identidad: el nombre, la nacionalidad y los vínculos familiares. Por lo tanto, cuando se priva de nacionalidad a una persona, está afectando gravemente su derecho a la identidad. Y tratándose de niños, bueno, para todos es grave, para adultos es grave y para los niños con más razón, ¿verdad? Por lo que desde esta relatoría la idea de trabajar en conjunto y eventualmente hacer un informe como comisión sobre el tema, en principio hay mucho interés. Quería saber si ustedes en algún momento del trabajo sobre este tema han considerado este tercer elemento de la identidad, que es el del vínculo familiar. Solo no hace falta que profundicemos, simplemente saber si de alguna manera lo han trabajado en el enfoque que ustedes están haciendo en cuanto al problema de la apatridia. Y una última pregunta es, ¿qué sucede cuando, si bien la legislación, los tratados, incluso la Constitución dice que es obligación aplicar el principio de garantizar la nacionalidad que adquieren en el lugar donde nacen, si es que no tienen posibilidad de conseguir otra nacionalidad? Pero hay una disputa, como dijo el señor, hay una disputa por no dar la nacionalidad, ¿verdad? El estado donde nació la persona quiere quitarse de encima esa responsabilidad y alude a que es el otro estado donde tiene orígenes por razones familiares el que debería hacerse cargo. Pero ¿qué pasa en esa disputa, en ese tiempo entre uno que niega darle su nacionalidad, el otro que tampoco se esfuerza mucho en otorgarla? ¿A quién corresponde? ¿Cómo se maneja esa situación? Bueno, les agradezco esta posibilidad de diálogo, porque es un tema que en América es un problema, y es un problema que haya la información que hay 12 millones en el mundo, pero que no sepamos cuántos hay en América, ¿verdad? El alcance del problema en América, que no exista esa información, ya nos señala que es un problema que tenemos que atender, ¿no? Que tenemos que conocer, y una vez que conozcamos poder abordarlo. Muchas gracias.
Thank you very much, Commissioner Ortiz. Well, my only question follows from hers. Do we have any data? Do we have any information which could helpfully tell us about numbers? And even though this is a general hearing, I think it would be useful to get a sense of where are the challenges most grave, and to have a sense across the Americas where the greatest concerns may lie.
Yeah, I'll kickstart the discussions. Starting with the last question, what could be the magnitude or the scope of statelessness in the Americas? Again, as it was stated, what we know, at least this is UNHCR's guess estimate, worldwide we're looking at 12 million people who are affected by the phenomenon of statelessness. UNHCR is only aware of 3.5 million individuals who are stateless, simply because registration on these individuals does exist. It's very, very difficult to come up with figures for a simple reason. The reason being that, unlike, for example, the area of refugee status determination, there you've got procedures, you've got entities that are responsible for receiving and processing individuals and keeping data that relates to the numbers of asylum seekers and those who are granted asylum or rejected or whose applications have been abandoned or withdrawn. There is at least a certain sense of understanding of the figures. We have been trying at UNHCR to come up with ways and means of having a grip on the numbers in individual countries, but again, it's a nascent initiative, and we hope that we'd be in the position to do that. That being said, which simply means that we don't know what the numbers are in the Americas, it's, I think, heartening to say that because of the combination of the application of jus soli and jus sanguinis in this hemisphere, you do not have great numbers of stateless persons. Maybe those who are at risk of statelessness, yes, and that could also be due to, again, like we said, the conflict of nationality laws, ineffective and dysfunctional registration systems, so on and so forth. And because, like we were saying, there is the application of jus soli in the hemisphere, and when a person leaves one country and goes to another and gives birth to a child in a country that applies jus soli, the risks of statelessness are diminished, but it doesn't mean that they do vanish, because there could also be some inadequacies with regard to the national laws or the gaps in the national laws of the country of origin that could also render this particular person vulnerable. Just one more thing before you chip in, Julia. The question on that was asked by Commissioner Gonzalez on groups that are disproportionately affected by certain measures, be they legislative or administrative, and what does UNHCR do? UNHCR, as you probably know, we are also driven by the same principle of non-discrimination in the area of refugee law, Article 3 of the 1951 Convention on the principle of non-discrimination. So in situations where this has arisen, UNHCR has intervened, and intervened at many levels. At the constitutional level, and you did state that you didn't want to be addressing situations in particular countries, but allow me to state that, for example, with regard to the Bahamas, UNHCR was invited by the Constitutional Commission to go and give a presentation on the views of UNHCR on the issue of gender discrimination as it is enshrined by the Bahamian Constitution. And also at the legislative level, because it's our responsibility to provide technical advice to states on how to ensure that laws are in conformity with international laws and principles, for example, embodied in the 1954 and the 1961 Convention. And at the very local level, we do intervene on what we call tolerance and reconciliation campaigns, which is what we did in one of the countries in this hemisphere last year, and a campaign that was also supported by civil society organizations, but also by the government, in order to instill a sense of tolerance and acceptance at the local level.
If I can just, I just wanted to talk a little bit about other countries, since that's where I contributed in terms of the documentation. And I'd like to talk about Kuwait to get at a few of the issues that were brought up. First, Kuwait is a country that has a facially neutral nationality law. There is nothing about that law that would suggest that there would be discrimination in the application of nationality law. But in fact, there are about 100,000 people in Kuwait who have been identified and marginalized and been told that a myth created around that they are not Kuwaiti, that in fact they are from other countries, a lot of other countries, many other countries, but not Kuwaiti. And that gets at the issue of what happens when you have a dispute, or not a dispute, but a question. The state in which you were born had a question. So first, when there's clear discrimination, but it's not the law, it's hard. It's hard to fix it. But hearings such as this, for instance, hearings in the UN system or in regional bodies are very important. And it's not changing the law. So it's getting other countries to be part of to participate and encourage the neutral application of the law. And that's what's going on with Kuwait right now. There's a lot of international pressure on Kuwait, and there are a lot of states offering technical assistance. Now, Kuwait says that a lot of they're called the Badoon, and that's Arabic for stateless, that there are a lot of Badoon who, in fact, are from Iraq or are from Saudi Arabia or from Syria, and they've come to Kuwait, and they've ripped up all their papers, and they did that because Kuwait has great benefits, and that would be a positive situation for them. But there's nothing whatsoever to suggest that they are in fact from Iraq or from Syria. But in Kuwait, they say that what they do is they say, well, we've now made this declaration, and it's your burden to prove that you're not Iraqi, which is impossible because you have to prove something that you're not. And it's impossible to do that. So what should be happening there is that Kuwait should have the obligation to demonstrate that in fact this person is, well, first the person should have the opportunity to make an application for nationality and to have a real, a meaningful hearing on that issue. And if for whatever reason the person is found not to be a national for discriminatory or good purpose or for appropriate purposes, but is found to be a national of another country, then there has to be engagement with the other country. Because in fact, one country cannot decide for another country who's a national. I mean, that's the whole idea of sovereignty. And so that has to be challenged immediately. And it goes back to the state again. It's the state's burden to demonstrate that this person is not a national, and it cannot do it by saying that you're a national of another state.
So very briefly, I'll try to address some of the questions raised. Commissioner Gonzalez's question about handling situations where prima facie non-discriminatory law disproportionately seems to result in certain groups not receiving citizenship. In general, we would say the way to handle that is to first do a thorough documentation of what's actually happening to show the disproportionate impact on a specific group. Because where even if the law is prima facie discriminatory, non-discriminatory, if the application can be shown to disproportionately harm a certain group, then it could still be called a discriminatory law or practice. In these situations, we usually also find problems of due process. If the system of application is sufficiently shaky that one group can, in result, suffer deprivation of citizenship, it's generally because of something I referred to, that it's a purely administrative mechanism through which nationality is being recognized, and due process protections are not being guaranteed in those processes. On the question of deprivation, whereby states may say quite some time later in a person's life that their citizenship was granted by mistake. To challenge such situations legally, again, we would try to do documentation to show a disproportionate and therefore discriminatory impact on certain groups of people if this is a systematic practice. Again, we would try to argue that there are due process violations in the way that states try to, after the fact, challenge nationality once granted. Within that framework of due process, we might even argue that there should be a statute of limitations for states to go back upon their own decisions. For many crimes, you can't prosecute someone 20 years later. So how does it make sense to prosecute an adult for, or to harm an adult based on the fact that they were ostensibly granted erroneous citizenship as a child? So very quickly, also, Commissioner Ortiz's question about the role of family ties. There is some interesting jurisprudence from the European system on the importance of family ties. A decision called Kuric, a decision called Genovese, recognizing that where there's a family link, sometimes an individual has a right to citizenship, even if the law is unclear or even if the law otherwise would not grant citizenship. And then this question about where states are resisting granting citizenship to children. I briefly referred to this in my remarks. We would argue, and recent jurisprudence from the African Committee on the Rights of the Child says that there is now a duty on states to be proactive. And where states argue that children have another nationality, states must cooperate. The burden cannot fall on the individual, much less a child, to prove what their nationality is, but that particularly the state in which the child is born needs to bear the responsibility for either ensuring that the second state conveys nationality, and if not, then granting their own nationality. But so that principle of state responsibility and duty to cooperate with another state would resolve this problem of states denying nationality based on attributing motives to a second state. Thank you.
Thank you very much. We know there isn't enough time to get full responses to everything, and we welcome the additional information which you will share with us. Want to say thank you very much. We look forward to a continued relationship, certainly with the UNHCR in relation to these matters. You've heard from the commissioners with special responsibilities that this is a matter the Commission will think of not just in the rapporteurship on migrant workers, but will treat as a cross-cutting concern. We do have a sense that country rapporteurs will also have a special interest in this issue, given the places where there are greatest concerns about this. Thank you very much.